Hey guys, I'm back with the series where we are discussing IPR and cyber law paper solution for the year 2016. In last video, we have completed till question 3, sub-question A. Now in this series, we are going to start the discussion from question 3, sub-question B. So in this sub-question, they have demanded for what are the rights awarded to patentee. Who is patentee? Let's just discuss those things. So basically, if my idea got certified or if my idea is got patent certification or my idea got patented, then owner of that particular idea, that person considered to be as a patentee. I hope it is clear. So what are the rights awarded to owner of that particular patent or rights awarded to patentee? First right, basically I have listed out 5 points in this particular mind map. So if you don't remember the whole answer, at least go and write this 5 points, highlight this 5 points, remember this, at least highlight this 5 points so that at least you can score 2 to 3 marks minimum, and rest of the things you can just explain in your own words. If you do not remember or if you are not be able to write the whole answer, if you don't remember the whole answer. So let's just start discussion. There are 2 numbers which we need to remember. As we know, in India, we have first established this act, that is Indian Patent Act 1970. In the year 1970. The same way you can remember this section, Patent Act 1970, 70, section 70. I hope at least one number now you can remember. Patent Act 1970, section 70. Now the second number which we need to remember is section 48. Try to remember this if you can. Otherwise just write it down what is basically section 48 stands for. So let's start discussion from here. Section 48 under Indian Patent Act 1970 provides you right to exploit the patent. Means you can actually try your idea in a best possible way, or you can actually utilize your idea in a best possible way. So that is what we mean by exploiting that particular idea. Try to use it in different manners so that we can get maximum output or maximum throughput as much as possible. Next is I can give license to use my patent to some other person, and that is defined under section 70 of Indian Patent Act. The same way, while assigning a license, I can fully assign my patent or I can partially assign my patent or my idea to some other person. So that is also defined under in section 70 only. Next is the right to surrender the patent. If in future I am not utilizing that particular idea, then I have full right to surrender my patent so that some other person can start using. Mainly, person surrenders their idea when government wants it for public welfare. So if my idea is quite unique, suppose I have invented some medicine which can cure a patient, cancer patient at stage 3 or stage 4, that is last stage, then if I have patent over that particular idea, that means that particular medicine is going to be costly because I'm going to include my profit in the same medicine. But to save more people, government can generate generic version of the same medicine. So in that particular time, sometimes I might need to surrender my patent as well, or government anyhow is going to use the same idea. I hope it is clear. And last is, if someone misuse or if someone uses my idea without my knowledge or without my permission, then I have right to go and file case against that particular person. Now, here, as you can see, subject to other provisions contained in Act, a patent granted under the Act shall confer upon patentee. First, I have exclusive right. Obviously, I can do whatever I want with my idea. That is what we mean by exclusive right. Where the subject matter of patent is a product to prevent third party who do not have his consent from act of making, using, offering for sale, selling or importing for those purposes that product in India. Now, when we talk about this particular point, it might possible that I have patented my idea in India. So it doesn't mean that some third person uses my idea, manufacture a product out of that idea. Instead of selling that idea or product based on that idea in India, he exports the same product to Nepal, Bangladesh, or in some other country. So in short, he violates the rules, patent rules. Now, under this particular act, we are also providing such restrictions that you cannot manufacture a product based on some idea, or you cannot use some other person's intellectual property without his consent or without his permission in India, or not in any other country as well. Or you cannot export or import product which violates intellectual property rights. I hope it is clear. Next is right to exploit the patent. We already discussed this. Here is the explanation for above point. Right to license, that is also we have discussed. Now that particular right is also comes under Article 70. Remember, Indian Patent Act 1970, 70 and Section 70. Right to assign, that is comes all under Article 70 only. Right to surrender, already discussed. Right to sue for infringement, file a case in a court. So that is also given here. So we are done with this particular question. Now let's start discussing the next question. That is, what is trademark? What are its essential elements? This is question 3, sub question C. Here we are going to discuss the same thing. Like I have purchased one iPhone, which looks and later on I identified that this particular phone is basically not manufactured by Apple, but instead it is some Chinese product. I have demanded iPhone, but that shopkeeper or in market I find exactly same piece which looks like, which works like exactly same like iPhone. But as we know, Chinese products are cheap as well as they are not long lasting. So I have purchased some product thinking that it is provided by Apple. And as we know, Apple provides products which are quite lifelong, or which are quite works for a longer life. They don't have short life. Now, if I use some iPhone phone and I don't know whether it is provided by Apple or from China. In short, one Chinese company for his own benefit spoils the name of some brand or some big company just for his own benefit. So spoiling an image of any other company, it is totally restricted under trademark. As you can see, a consumer is dumped if he buys a commodity presuming it's to have originated from a certain identified source when actually it is not, and later he finds that commodity is substandard. Just remember this one. Now, same thing is defined here. You can just read out this particular paragraph. Next part is, what are the essential elements? Now let's just discuss essential elements. I have provided this diagram here. First, your trademark should be distinctiveness. It should be unique. It should not be similar to any other company which is dealing in physical or service goods. It should not be similar to that. A trademark would be considered a good trademark when it is distinctive. Distinctive means non-repetitive. The trademark should preferably an invented word. Let's suppose many company uses some words which we do not use in our day-to-day life. For example, Samsung, Acer. So these are the few names or words which we are not using in our day-to-day life. At the same time, they are very easy to pronounce as well. And it is very easy to spell as well. So our trademark should be easy to spell, easy to pronounce, as well as it should be some unique word. A word or a name should be easy to pronounce and remember. As I said, Sony, very easy to pronounce. Zen, very easy to pronounce. And Ford, again very easy to pronounce. So make it simple and short. And try to make it as friendly as possible with others so that they can easily remember. For example, one website which is present over internet, which deals in a car. So they have just named in India Car Wale. So one can easily remember it, right? It is so simple to remember it, Car Wale. Then same way in case of device mark means suppose we have some trademark on our laptop, computer, smartphones, tablet. So this device should be capable of being described by a single word. Some trademarks are descriptive, some trademarks are not descriptive. Let's suppose if we talk about OLX, so it is quite descriptive. Or if we talk about Ola cab, so it is descriptive that what this particular mark states there. As we read the word cab, we can predict that okay, this company dealing in cab. Now when we talk about Apple, so they don't have any descriptive type. Just by looking at the icon Apple, one cannot describe that this particular company deals in some fruit or fruit salad, or whether this company is dealing in some electronic products. So there are two types of trademark basically. There are many classes, subclasses as well, but we are not concerned right now with respect to our question. Then it must be easy to spell correctly and write legible. It should not be descriptive by may be suggestive of quality of goods. So it must be, it should specify quality of the goods. For example, a mark AI would generally suggest superior quality. Same way it should be short. For instance, take flex, banrin, or it should be appeal to eyes as well as ears. It should be, now these are some simple Bolvachan points only, so you can just remember it as per your needs and requirement. It should not belong to class of marks prohibition. Now remember one thing, after 1950 somewhere, okay, after 1950 somewhere, government banned use of national emblems or national signs or some freedom fighters. You cannot use Gandhiji as your trademark, or you cannot use Ashok Chakra as your trademark, or you cannot use Indian flag or national anthem as your trademark, because this all belongs to national emblems or signs. So accept this, and at the same time you cannot also use some gods or goddesses. For example, some Indian gods or goddesses in your company's branding. I hope it is clear. Thank you.